Yeah, good evening. I need your support, right? Could you please tell me what we have discussed? What have we discussed in our last session? Do you hear me?
Yes, sir.
Yes, Amanda, right? Did you attend the last session, previous session?
Yes, sir.
So tell me, right, what we discussed.
Consequences of violating the act. Last
Which act?
topic,
Which act?
offences and penalties.
Mona act together. Hello? Mokhad act එක?
Minimum retirement age of worker. Act number
Okay.
28.
Right. Okay. Minimum retirement age of Workers Act. And then tell me, did we discuss the what do you call this budget relief allowance of Workers Act 2005 and 2016?
Yes, sir.
Okay. Maternity benefits ordinance? Yes, we did. And what about workman compensation ordinance?
Already discussed, sir.
Already discussed. Then everything has been discussed. No, now, therefore, what is the lesson number today?
28, sir.
Okay, 28. So as we have discussed everything, ETF Act.
Yes, sir.
Not EPF, ETF, Employees Trust Fund. Check it and let me know.
Done, sir.
Done. Okay. Okay. Right. Now, today, with regard to what do you call this labor law, we have covered everything. So as we have couple of sessions to go, I will discuss with you a very important topic which is not there in your syllabus. Which is not there in your syllabus, but it is very important. Very important. So today my topic to discuss with you is this. Do you see the presentation? Misconduct, disciplinary procedure, and punishment. Do you see that?
Yes, sir.
Yes, sir.
Right. Misconduct, disciplinary procedure, and punishment. This is very important, even though it is not there in your syllabus. So therefore, take your note. Misconduct, disciplinary procedure, and punishment. There are two presentations in this regard. Even this presentation takes around three sessions, at least two. Okay. Please let me know, first of all, the company has their own disciplinary procedure. But in labor law, there is no precise disciplinary procedure. However, there are court cases and court decisions with regard to discipline. Based on those court decisions, I have prepared this presentation based on court decisions. Okay, right. My presentation contains this. What is misconduct? VOP note, vacation. VOP means vacation of post notice. Investigating complaints on misconducts. Investigate කරන්න කොහොමද? The so-called letter. නිදහසට කරුණු විමසීමේ ලිපිය. Explanation by the employee. සේවකයා විසින් කරුණු දැක්වීම. Suspension or interdiction by the employer. වැඩ තහනම් කිරීම. තාවකාලික වැඩ නැවැත්වීම. The charge sheet එකක් දෙන එක. Holding a disciplinary inquiry එකක් පැවැත්වීම. Final report of the inquiring officer. Punishment, warning, imposing fines, demoting, termination of service, etc. For forums available to review the punishments on disciplinary grounds. Labor Tribunal, Labor Department of Labor, Conciliation, Arbitration, Industrial Courts, and Labor Tribunal orders, arbitration awards, industrial court orders, and then implementation of orders, awards, and role of the Department of Labor, and the final outcome of labor dispute. So these are the subject matters containing in my presentation. Do you hear me? So is it visible? Is this visible?
Yes, sir.
So you have to take your note. Content. What is misconduct, VOP notice, and all this. You take your own note.
So can you make it large?
Let me. Is it visible?
Yes, sir.
Right. Once you finish, let me know. Have you done? Ivarada?
No, sir, still writing.
Okay. What about now?
Finished, sir.
Dinesh?
Complete, sir.
Okay, right. Moving to another slide. So, what is misconduct? You know, according to, the website www.employment.gov.nc, New Zealand, resolving problems like, I have quoted certain, definitions from website. Because we don't have any precise definition. Misconduct is when an employee does something wrong, either by doing something, not doing something, or through their behavior. Through their behavior. Misconduct is when an employee does something wrong either by doing something, මොනවා හරි කරමින් වැරදි දෙයක් කරොත්, නොකර හිටමින් වැරද්දක් කරොත්, through their behavior or එයාලගේ behavior එකත් එක්ක. This may justify some disciplinary action being taken by the employer. This may justify, මේක සාධාරණීකරණය කරනවා, some disciplinary action. විනයානුකූල ක්‍රියාමාර්ග being taken by the employer. සාම්පුතා විසින් ගනු ලබන විනයානුකූල ක්‍රියාමාර්ගමයි. Another definition is misconduct is failure to fulfill the conditions of employment in the contract of service. Misconduct is the failure to fulfill the conditions of employment in the contract of service. සේවා ගිවිසුමේ තියෙන conditions සම්පූර්ණ කිරීමට අපොහසත් වීම misconduct එකක්. Examples include theft, dishonesty, disorderly or immoral conduct at work and insubordination. Right? උදාහරණ තමයි හොරකම් කිරීම, අවංක නොවීම, right? Order පිළිපදීම නොපිළිපැදීම, disordered, immoral conduct at work and insubordination, සහයෝගය නොදක්වීම. Okay, so I'm not reading, you have to take your note. I have already read it. It is your duty to take your note. What is misconduct? Kavisa, are you okay?
Yes, sir.
Right. Shall I move to another slide? Next slide.
Okay, sir.
So again, what is misconduct? Providing universally accepted concrete definition for the word misconduct is not easy. Universally accepted. විශ්වීය වශයෙන් පිළිගන්නා definition එකක් හොයාගන්න අමාරුයි. It depends on the case and each circumstances. Here, depend වෙනවා. එක එක case එක සහ අවස්ථානුකූලව. Sometimes sharing a post in the Facebook can constitute a misconduct. Government workers, senior executive officers in the government service, according to the establishment code, they don't have political rights. I have noticed that even very senior officials, they are sharing posts through WhatsApp and Facebook. So, Public Administration, Ministry of Public Administration has issued a circular preventing such, activities. So therefore, sometimes sharing a post in the Facebook can constitute a misconduct as well. However, remember that we are discussing this, the misconduct and disciplinary procedure with regard to the private sector workers, not in relation to government officials. Okay. Next subtopic, what is misconduct? Again, first bullet form, providing universally accepted concrete definition for concrete definition for the word misconduct. It is not easy. Misconduct is not easy. Oh, just 1 second. මට තේ එකක් දෙනවා. Sorry, මම මගේ ගෝලියෙකුට තේ එකක් ගෙන්න කිව්ව එකත්. Sorry. Next bullet. It depends on the case and each circumstance. Right. Then sometimes, next bullet form, sometimes sharing a post in the Facebook. Can constitute a misconduct. Sometimes sharing a post in the Facebook can constitute a misconduct. Okay. So moving to my another slide. Right. So just 1 second. Then what is implied terms? What does it mean? Implied terms include statutory rights, collective agreements, terms, arbitration, LTOs, customs, etc. Right. These are some implied terms with regard to a misconduct. Okay. Just 1 second. Give me a 1 second. These are implied terms. What does it mean? Right? With regard to, just make it larger. Right. Implied terms include statutory rights. There is no precise definition, as I told you. However, there are some terms, associated with misconduct. These implied terms include statutory rights, collective agreement terms, arbitration or LTOs, customs, etc. These are practices. I mean, implied terms. An important implied terms is the duty of mutual trust and confidence, which is implied in every employment contract. These are very important. Further, in continuing a contract of service, the court will, if necessary, supply the implied condition as to reasonableness where duties are not fully defined. මේ කියන්නේ යම්කිසි වැරද්දක් වුණාම මේ statutory, implied terms කියන එක වැදගත් වෙනවා. ඒ implied terms කියන්නේ නීතියෙන් හා සම්බන්ධ දේවල්. දැන් කෝට් එක තමයි, උසාවිය තමයි decide කරන්නේ මොනවද, the court will, right? Service of court will, if necessary, supply the implied condition as to reasonableness where duties are not fully defined. Duty එක හරියට define කරලා තියෙන නැතුව misconduct එකක් කියලා කෙනෙකුට දඬුවමක් පැවරුවොත් court එක බලනවා මොනවද implied terms කියලා. Implied terms වෙන්නේ statutory rights. ඒ කියන්නේ නීතියෙන් label එකේ තියෙන දේවල්, collective agreement වල තියෙන දේවල්, පහුගිය නඩු තීන්දුව, right? මේ වගේ දේවල්. Okay? So you take your note. What is implied terms? ඔක්කොම මේ ටික ලියාගන්න. මේ implied terms කියන්නේ මේකේ ලියලා නැති පත්වීම් ලිපියේ නැති එහෙත් අනිවාර්යයෙන්ම බලපාන දේවල් පත්වීම් ලිපියේ මොනවද තිබුණත් කාම්කරු නීති අනපනත් වල තියෙන ප්‍රතිපාදන උසාවි තීන්දුව LT award වල ඒවා තීන්දුව අනිවාර්යයෙන්ම implied terms වෙනවා පත්වීමේ සේවා ගිවිසුමේ. We have learned this at the beginning. Finish? Shall I move? Have you done?
Yes.
Then again, what is misconduct? In the instant case, it is noted that acts of misconduct previously committed by the workman include. So I'm quoting, this is the last one. Supreme Court, CS means Supreme Court. Appeal, this is the case number. Kottagala Plantation Limited versus Ceylon Planters Society. Right? Case was decided on 15th of December 2010. Right. Based on this, because I told you, there is no, precise, what do you call, the code or any legal document with regard to misconduct and the punishment. We are considering the court decisions. Based on the Supreme Court decisions on this case, in the instance, what Supreme Court says, in the instant case, it is noted that acts of misconduct, misconduct, විසමාචාර ක්‍රියාවක යෙදීම previously committed by the workman. Workman committed by. මෙන්න මේවා කෝට් එක highlight කරනවා. Unsatisfactory attendance. Purchase of diesel in an unauthorized manner for personal use. Leaving the estate without obtaining leave. Failure to report for duty once the period of leave expires. Acting in breach of the terms and conditions of employment and managing a tea plantation that does not belong to the applicant, appellant and respondent. Then ඇයි මේව කියන්නේ? මේ misconduct කියන එක තහවුරු කරන්න. නඩු තීන්දුව වලින් තමයි කියන්න වෙන්නේ. එහෙම නැතුව අහවල් එක කියලා කියන්න බෑ. ඒක නඩු තීන්දුව ඇසුරෙන් තමයි අපි තීරණය කරන්නේ ඒක misconduct එකක්ද නැද්ද කියලා අපිට අනුව. In the instant case, it is noted that acts of misconduct previously committed by the workman include මෙන්න මේවා. එතකොට උසාවිය පිළිගන්නවා ශ්‍රේෂ්ඨාධිකරණය පිළිගන්නවා මේවා මොනවා කියලාද? misconduct විසමාචාර ක්‍රියා කියලා. හරි? එතකොට ඒ අනුව අපිට තීරණය කරන්න තියෙන්නේ මෙන්න මේ කියන දේවල් මොනවාද? විසමාචාර ක්‍රියා. leaving the estate without obtaining leave. මෙතන estate කියන්නේ මේ කේස් එකට අදාළ. එහෙනම් අපි කියන්න ඕන මොකද්ද පොදුවේ ගත්තොත්? leaving the workplace without obtaining leave. Okay? තේරෙනවද ඔයාලට? hello? පැහැදිලිද?
Yes, sir.
right. ලියාගන්න මේ. ඉවරද? Do you need more time?
Finish.
Okay. Now, statutory provisions relating to misconducts, right? Although most of the time our acts here, A should be capital, otherwise just let me do it. Our acts, A should be act. මේ විදියට simple A අකුර දැම්මොත් මොකද වෙන්නේ? ක්‍රියාකාරකම් වෙනවා. acts නීතිමය කටයුතු සම්බන්ධයෙන් නම් නීතියක් ගැන කියනවා නම් acts කියන එක A capital වෙන්න ඕනේ. Right? So statutory provisions relating to misconduct. Although most of the time our acts do not use the word misconduct, the words used in some acts, again here, acts capital, A capital. In used in some acts indirectly accept the concept of misconduct. අපේ නීතියේ මේ misconduct කියන වචනේ කම්කරු නීතිවල ඒ විදිහටම භාවිතා නොකර වුණත් සමහර කම්කරු නීතිවල ව්‍යංගයෙන් මේ concept එක පිළිගනු ලබනවා. Wages Board's Ordinance number 27 of 1941, section 2, read with regulation 2 and list B of the schedule acts omissions. Schedule of the schedule metana eka simple. Schedule of the schedule acts. Acts kiyane metana acts wenne නීතිය නෙමෙයි ක්‍රියාකාරකම්. Right? Acts or omissions. Omissions kiyane ඔබ දන්නවනේ අතරින් වැරදි ඒවා. Sorry. Although most of the right. And then Sopanopis Act, Regulation 18, authorized deduction from the salary. Acts omission මේ හැමතැනම මෙතන acts කියලා කියන්නේ ක්‍රියාකාරකම් කියන එක ආයි මං හදන්න යන්නේ නැහැ. ඔබට මතකද authorized deduction ගැන කතා කරා? මතකද? Do you remember we discussed authorized deduction under Sopanopis Employees Act and the Wages Board's Ordinance? Do you remember? Authorized deduction පඩියෙන් අඩු කරන්න පුළුවන් මොනවද කියලා? අන්න ඒව ඇතුලේ hello, do you remember? If you don't remember, right, refer to my note. And the Termination Act, Gratuity Act, Employment of Trainees Act, Case Law, Customs, Common Law Principles, Maternity Benefits Ordinance. මේ හැම එකකම තියෙනවා ව්‍යංගයෙන් පිළිගන්නවා misconduct කියන ඒවට දඩුවම් දෙන්න ඕන කියන එක ව්‍යංගයෙන් පිළිගන්නවා. Okay. Next subtopic, statutory provisions relating to misconducts. Statutory provisions relating to misconduct. එයටද ලියන්න. Although, most of the time, our legislations acts වෙනුවට මම වෙන වචනයක් පාවිච්චි කරනවා. Our legislations. Do not use the word misconduct, comma. The words vachana used in some legislations indirectly accept the concept of misconduct. තරු හරි ඊතල හරි මේ තියෙන විදියට ලියා ගන්න. Wages Board's ordinance section 2 read with regulation 2. Read with regulation 2 and list B of the scheduled acts stroke commissions. ඔබට මතක තියෙනවා නම් authorized deduction කියලා අපි කතා කරා. ඒ වලට තමයි මේක එන්නේ. And then next one. Sopanopis Act. Put a dash. Regulation 18. Regulasi, 18 වෙනි regulasi. Within bracket. Authorized deductions from the salary. On acts, simple A, acts stroke commissions. And then termination act. Put it as section 2 within bracket 4. Section 2 within bracket 4. හතර. And then next, Gratuity Act, A capital. Gratuity Act, A capital. Put it as section 13. You don't need to write everything. Case law. And then common law principles. Next, maternity benefits ordinance. Okay, then again, the explanation. Sopanopis Act and Wages Board's ordinance. Right, we discuss this one, Sopanopy, Wages Board and Sopanopis. What are those? Sopanopis Act and the Wages Board ordinance, up to 5% of fines from the salary can be imposed on the employee by the employer in respect of any of the following acts or omissions. I have not cited here everything. Then you have to refer to. We have discussed all these things under the Wages Board's Ordinance and the Shop and Office Employees Act. I have put one here, absent from the work without reasonable excuse. This is misconduct. Indirectly, by our labor legislations, accept the concept of misconduct. Okay. And then the Gratuity Act, Section 30. Any workman to whom a gratuity is payable under Part 2 of this Act and whose services have been terminated for reasons of fraud, misappropriation of funds of the employer, willful damage to the property of the employer, or causing of loss of goods, articles, or property of the employer shall forfeit, රඳව ගන්න පුළුවන්. Such gratuity to the extent of the damage or loss caused by him. වැරද්දේ තරමට ප්‍රමාණයට අදාළ gratuity එකෙන් ප්‍රමාණයක් රඳව ගන්න පුළුවන්. ඒකෙමුත් මොකද්ද කියන්නේ? misconduct කියන එක පිළිගන්නවා මොකක් විසින්ද? directly ඒ වචනේ පාවිච්චි නොකලට අපේ law එක විසින්. Do you understand, Dinesh?
Yes, sir.
Dilini,
Yes, sir. Clear.
Amanda,
Yes, sir.
Havisha,
Clear, sir.
Pavani Ayodhya,
Yes, sir.
Sitmi,
Clear, sir.
Yamunu,
Clear, sir.
Tesani, Tesani, she's not there, right? Then take your note. Statutory provisions relating to misconduct. Again, the continuation. Shop and Office Act and Wages Board's Ordinance. Right. I have given the reference and the Gratuity Act. You take your note. Finish? Ivarada?
Yes, sir.
Okay. Again, continuation. Gratuity Act, Section 13, you don't need to write all these things. And the Termination Act. Termination of Employment Act number 45. What it says? Section 4, Section 2(4) actually, not 4. For the purpose of this act, the scheduled employment of any workman shall be deemed to be terminated by his employer if for any reason whatsoever. Otherwise, than by reason of a punishment imposed by way of disciplinary action. disciplinary action එකකට හේතු කොටගෙන සේවයෙන් පහ කිරීම පිළිගන්නවා. The service of such workman in such employment are terminated by his employer, and such termination shall be deemed to include these are the the provisions. මේකත් අපි ලියාගමු. Termination එක විතරක් ඇති. මෙතන පෝ එක එන්න ඕන මෙතෙන්ට. section 24 4 පල්ලෙහාට ගිහිල්ලා තියෙන section 24. Let me make it. Right. This one. Employment of trainee private sector. So you don't need to write that one. This one. Employment, termination of employment. Act number 45 of 1971. ඒ කියන්නේ විනය කාරණයක් හේතු කොටගෙන සේවයෙන් පහ කිරීමට හැකියාව තියෙනවා කියන එක. එයාට හැබැයි තියන්න පුළුවන් ඊට පස්සේ ඒක වෙනම කාරණයක්. I think you have done. Right. So I'm moving to another slide. Maternity benefits ordinance number 33 of statutory provisions relating to misconduct. Section 10A1 the employment of a woman worker shall not be terminated by reason only for her pregnancy or confinement or of any illness consequent on her pregnancy, consequent to on her pregnancy or confinement. Where an employer is prosecuted for the offense of acting in contravention of the provisions of subsection 1, the burden of proving that the employment of a woman worker was terminated by reason of some fact other than her pregnancy or confinement or any illness consequent on her pregnancy or confinement shall be upon the employer. මොකද්ද මේ කියන්නේ? මේ maternity benefits මාතෘ ප්‍රතිලාභ ආච්‍යා පනතට ප්‍රසූතිකාදාර ආච්‍යා පනතට අනුව කාන්තාවකගේ ගැබ් ගැනීම දරුවකු පිළිසිඳ මේ කාරණා හේතු කොටගෙන සේවයෙන් පහ කරන්න බෑ. එහෙම කරලා තිබුණොත් burden of proof ඒක prove කිරීම ඒක කලේ pregnancy එක හින්දා නෙමෙයි වෙන කාරණයක් හින්දා කියන එක prove කිරීම උසාවියේදී කම්කරු දෙපාර්තමේන්තුවේදී ඒ අදාළ කරුණු ඔප්පු කිරීමේ භාරය කියලා අපි කියනවා යනවා කාටද work හාම්පුතාට. Okay, right. It's your time to take note. I have read it and I don't need to, read it by one word by word. It is up to you to take your note. When you finish, let me know. Otherwise, I don't know. Hello, did you finish?
Yes, sir.
Okay. Next one.
Still,
VOP
sir,
notice.
can you put it again? Last line, sir.
Yes, this is the one. Shall I move?
Okay, sir. Thank you.
So, VOP notice, the concept. There is no precise definition, but I'm taking something from this court decision. Nelson de Silva versus Sri Lanka State Engineering Corporation. It says the concept of vacation of post involves two aspects. VOP means vacation of post. The concept of vacation of post involve vacation of post කියන්නේ සේවය හැර ගියා කියලා ලියුමක් ගන්න. වැඩට ආවේ නැතුණා. ඒක ගහන්නේ වැඩට නොදන්නවා සේවයට නොපැවුණා. Right? If you fail to, right, inform that you won't be able to attend to work and then you absent, then the employer has right to issue a VOP notice, vacation of post notice. This court case says, the court decision says, the concept of vacation of post involves two aspects. එකේ ආකාර දෙකක් තියෙනවා. One is the mental element. Mental element, මානසික අංගය. That is the intention to, right, desert and abandon the employment and එයාට උවමනාවක් තියෙනවා mental element එක. That is the intention to desert. සේවයට වාර්තා නොකර ඉන්න එයාගේ intention එකක් තිබුණා. හිතාමතා. Right? And abandon the employment and සේවය අතාරින්න ඕන කියලා intention එකක් තියෙනවා. Second is the failure to report at the workplace of the employee. Second එක තමයි failure to report to work. ඒ කියන්නේ මෙහෙම. දැන් කෙනෙකුට හදිසි අසනීපයක් වෙලා. If you fallen ill, you may not be able to inform the company because of the situation, and you will be hospitalized. You will not be able to report at the workplace, but you don't have intention to vacate the post because it's a sudden accident. You need to report to work, but unfortunately you can't report to work. And also with the situation, you won't be able to inform the company that you won't be able to attend because of this accident or whatever it is. So then you don't have any mental element, or the mental element is not there. You don't have any intention to vacate the post. So in case if you will be sued and a VOP vacation of VOP vacation of post notice by the employer, right? You can go to labor tribunal because it is a termination, and then the court will decide whether the employer is right or wrong. Okay, right. To constitute the first element, it must be established that the first element, like a mental element, to constitute the first element, it must be established that the applicant is not reporting at the workplace, was actuated by an intention to voluntarily vacate his employment. ඒක ඔප්පු කරන්න ඕනේ. ඒ කියන්නේ පළවෙනි එකකින් කියන්නේ යාට පැහැදිලිවම මට මේ රස්සාව ඕනේ නැහැ දාලා යන්න උවමනාවක් තිබුණා. එහෙම නැත්නම් ගණන් ගන්න. The physical absence and the mental element should coexist for there to be vacation of post in law. නීතියට අනුව මේ දෙකම තියෙන්න ඕන post එකක් vacate කරන්න. A temporary absence from a place does not mean that the place is abandoned. There must be shown also an intention not to return. So, to the physical failure to perform a contractual duty, there must be added the intention to abandon future performance. A reasonable explanation may negative the intention to abandon. So, what is important for us to take this court decision is an employer cannot terminate, right? He can terminate, but employer has to think twice before issue a VPOP notice. Why this person has not attended to, has not been attended, has not attended to work. The employer also have the responsibility to check whether this man is ill, or at least the one notice has to be sent. There is no written law in that regard, but it is the duty of the employer to ask the absent employee to return to work. Okay, because he may be, met with an accident, critical illness. Okay, right. VOP notice and this is also important, right? VOP notice. You take your note. මේක ලියා ගන්න. Have you done? Finish? ඉවරද? තව නැද්ද?
No, sir, still writing.
Okay. එන්න. What about now? Shall I? I'm moving. Is it okay?
No, sir, still writing.
Okay. Dinesh, have you done?
Yes, sir. done.
Yes, sir.
Okay, right. Next. Serious or grave misconduct and minor misconduct. What are the serious misconduct and what are the minor misconduct? Serious misconduct is labeled serious because it can have the effect of destroying or undermining the relationship of trust and confidence between an employee and employer. Serious misconduct කියන එක label කරනවා serious හැටියට. ඇයි? එවැනි තත්ත්වයක් සේවක සේව්‍ය සම්බන්ධතාවය සේවකයා හා හාම්පුතා අතර තියෙන විශ්වාසය, confidence එක, ඒ වගේම සම්බන්ධතාවය undermine කරනවා, අව탁සේරු කරනවා. ඒකයි ඒවට serious කියන්නේ. Without this trust and confidence, trust එක and confidence, an employment relationship can't continue or cannot be continued. An instant of minor misconduct, which is not serious, doesn't on its own undermine or destroy the relationship. Minor conduct, එහෙම සේවක සේව්‍ය සම්බන්ධතාවය විනාශ කරලා දාන්නේ නැහැ. undermine කරන්නේ නැහැ. An instance of misconduct would not justify dismissal unless it is repeated. ඒ වගේ minor misconduct එකකට සාමාන්‍යයෙන් සාධාරණීකරණය කරන්න බෑ සේවය අවසන් කරන්න. මිස්කන්ඩක්ට් එකක් කරාම විසමාචාර ක්‍රියාවක් නිසා සේවය අයින් කරන්න පුළුවන්. නමුත් මයින් එකකදී එහෙම අයින් කිරීම ජස්ටිෆයි කරන්න සාධාරණීකරණය කරන්න බෑ. ඒකයි කියන්නේ. Okay? Okay, right. Subtopic: serious stroke grave misconduct. Serious stroke grave misconduct and minor misconduct. And minor misconduct. First bullet. Serious misconduct is labeled. Serious misconduct is labeled as. Serious misconduct is labeled as serious because it can have the effect of destroying or undermining. Destroying or undermining. The relationship of trust. The relationship of trust and confidence. Confidence between an employee and employer. An employee and employer. Full stop. Without this trust and confidence, without this trust and confidence, an employment relationship cannot be continued. Cannot be continued. Next bullet form. An instance of minor misconduct which is not serious, does not on its own, comma, on its own, comma, undermine or destroy. Destroy the relationship of of trust and confidence, between an employee and employer. Full stop. An instance of misconduct. An instance of misconduct would not justify a dismissal unless it is repeated. ඒක නැවත නැවත කරන්නේ නැත්තම් එවැනි එක්තරා අවස්ථාවකදී සිදුවන දෙයකට සේවයෙන් පහ කිරීම justify කරන්න බෑ. සාධාරණීකරණය කරන්න බෑ. Right. Next subtopic. Right. I will stop at 10 today. Right. Types of misconduct. Next subtopic. Types of misconduct. විසමාචාර ක්‍රියා මොනවද? විසමාචාර වර්ග. Types. Remember, categorizing or naming all the misconduct is not possible task. එහෙම කරන්න බෑ. But undermentioned acts, ක්‍රියාකාරකම් or omissions, වැරදි, can be considered as misconduct. Okay? So, take your note, types of misconduct subtopic, categorizing or naming නම් කිරීම, naming all the misconducts is not possible task. Full stop. Is not possible task. Full stop. But undermentioned, පහත දැක්වෙන undermentioned acts, පහත දැක්වෙන ක්‍රියාකාරකම් acts, ඇලයිරක් stroke omissions can be considered as misconducts. Number 1, absence and late attendance. Number 2, negligence. Number 3, insubordination. සහයෝගය නොදක්වීම, insubordination. Number 4, abuse. Number 5. Number 5, assault. Assault. පහර දෙනවා. Number 6, false allegations against superior. False allegations against superiors. False allegations against superiors. superiors ලට එරෙහිව බොරු චෝදනා නගනවා. drunkenness, බීමත්කම. drunkenness. Number 8, disloyalty to employer. Disloyalty to employer. Number 9, competition. Under competition, there are a couple of things. A, see, capital A. Aiding the competitor. තරඟකරුවන්ට ආධාර කිරීම. තමන් වැඩ කරන ආයතනයට අදාළව තමන් වැඩ කරන ආයතනයේ තරඟකාරී තවත් ආයතන තියෙනවා නම් ඒ තරඟකාරී ආයතන වලට උදව් කිරීම. aiding, ආධාර දීම, අනුබල දීම. B, selling product of competitor. තමන්ගේ ආයතනයේ බඩු විකුණන වෙනුවට තරඟකාරී ආයතනයත් එක්ක යටි කූට්ටු වැඩ කරලා ඒගොල්ලන්ගේ භාණ්ඩ ප්‍රොමෝට් කරනවා, විකුණනවා. selling product of competitor. C, competing with the employer. තමන්ගේ හාමුදුතා එක්ක තරඟ කරනවා වෙනත් අය එක්ක එකතු වෙලා. D, non-competitive, non-allied competitive, outside employment. Number 10, disparaging remarks. Disparaging remarks. Disparaging remarks. Just 1 second. Number 11, failure to report to theft. 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 Yes. Failure to report to theft or other dishonest act. Or other dishonest act. Right. Number 12, willful damage to employer's property. Willful damage to employer's property. Put it as sabotage. Willful damage to employer's property. Put it as sabotage. Number 13, dishonesty. Keep this note because you can't get anything, any kind of this kind of note from anyone else. Because this should be included in the syllabus. Because when you are handling HR, if you are to handle HR matters in a company, you need to understand, right, how to handle how to, what would be the procedure, disciplinary procedure, right, according to law in the sense, the court decisions. And number 13, dishonesty. Dishonesty. Number 14, theft and misappropriation. Theft and misappropriation. Theft and misappropriation. Number 15, loss of confidence. Loss of confidence. 16, disobedience. Seventeen, refusal to carry out. Refusal to carry out. Refusal to carry out lawful instructions. 18, refusal to accept transfer. Number 19, refusal to perform. Refusal to perform. Refusal to perform reasonable overtime. Number 20, sexual harassment at workplace. 21, misconduct misconduct outside the workplace, misconduct outside the workplace, and working hours and not in course of employment. Number 22, misconduct and trade union action. Misconduct and trade union action. Under this first bullet, you have the trade union right, but you cannot undertake unlawful strike. First bullet, under 22, unlawful strike. Second bullet, go slow. Hemming වැඩ කරන්න බෑ. පඩිය ගන්න ඕනේ පඩියට හරියන්න වැඩ කරන්න. Go slow කියන්නේත් එක strike වර්ගයක්. But in Sri Lanka, unlawful strike and go slow are considered as misconduct, not recognized as lawful strikes. Number 23. Intimidation. 24. Some numbering is not correct. 24, fraud. So these are the misconduct, ladies and gentlemen. Okay? Is it clear? Hello?
Yes, sir, clear.
Right. Today, I will stop my lesson. Now we are discussing something else because today you said 28th or 29th. Session number?
28.
28, right. Up to, this takes another 2 days and then 30 almost. And
28, sir.
oh yeah, 28. Then it takes another 2 sessions. 2 sessions definitely. It goes 3 hours exactly. But today I didn't give you any intervals. But I need to stop today. But next day it goes up to 3 hours or 2 hours and 45 minutes, and it may goes another 2-3 sessions to complete this one. And then I will summarize, taking at least the 2-3 sessions. I will summarize all labor legislation, so main points. Okay, so please attend. Right, from next day onwards, don't miss the lessons. Okay, Dinesh, is it clear?
Yes, sir.
Do you permit me to stop now? Nobody
Yes, sir.
responding.
Yes, sir.
Right. So just I'm stopping right now, and we will discuss the next day. Oh, good night for everyone.
Good
Thank you
night,
very
sir.
much,
Thank
sir.
you,
Good
sir.
night,
Okay, good night.
sir.